Good morning. Get your coffee, maybe some popcorn. This is gonna be good, folks.
Like to
Oh yeah. All right. Check, check, check. Oh. Ladies and gentlemen, welcome to Lone Wolf Live. We have stuff to watch this morning, and it's good stuff. It's fun stuff. Like I said, grab your coffee, get some popcorn, whatever you like. It's noon, most places, some places, all the good places. The dogs are barking in the background. It's gonna get funky. All right. So, welcome to the 25,000 subscriber special. I'm your Lone Wolf Oosel, and I'm here to show some videos, and we have some interesting things today. We're going to start off with one that some people may have seen, and it's about 30 minutes long. It's from Judge Rossi's court. I've seen part of it. I haven't seen all of it. I'm dying to see how it ends. It's quite a spicy affair. Yeah, thank you everybody for showing up. Thank you to all of my constant viewers, all of the new subscribers, everybody who's dropped by this morning. It really means a lot to me. This is a really cool thing. I you know, you can ask Dreams and Wi-Fi here. They know distinctly that I always say I'm never going to make 25,000. I don't believe I'm going to make 30,000, but hey, we're going to try. And we'll celebrate that when that happens too. But I did make kind of a little promise last time I was live that I was thinking about doing something different once we hit 25,000, and I'm going to kind of hold to that. So today is kind of the first day of Lunch with Lone Wolf, and this is going to be kind of a new weekly thing that I'm going to do at 11 o'clock or 12 o'clock Eastern Standard Time on Saturdays, if I can. It'll be a scheduled live stream, just like this one is. Just not necessarily a special 25K celebration like this one is, but it's just gonna watch some court cases that I necessarily wanted to watch but didn't have time to watch, or didn't have time to make a video out of. That type of stuff. So, hey. Thank you, everybody. I'm gonna just get started here. I have a lot of stuff. Stay tuned for the very last video that we're gonna watch today. I found a video of a guy who earnestly believes that Chili needs to be freed. That's right. Our favorite Chili DeCastro has a person out there who has made a video insisting that all the injustices have been done, and it is absolutely insane. The reason I found it, though, I just want to throw this out there, is because a person who purports to be an actual lawyer of some description did a review of the video and was talking about how this guy was completely right about everything he was saying. And obviously another friend of Chili's, and he did, the lawyer guy actually states in the beginning of his little review that he's actually a friend of Chili's. So, um, the this video, I haven't seen all of it, but the bits of it I've seen are cherry, and it's going to be a little different. I may actually have to like start and stop it and comment over it old school style, because oh my god, the things this guy says are just so out of left field. But before we get to that, we're going to warm up with something that most people have probably seen most of, if not all of. It's two ladies in front of Judge Rossi. It's a personal protection order, which we don't normally do, but one of the ladies is really upset because the other lady is having an affair with her soon-to-be ex-husband. Be forewarned, spicy language incoming. Had the kids' ears if you have kids present. Shield them. Put in your earphones. I'll try not to be blowing out anybody's eardrums. So, yeah. This is gonna be. Ladies and gentlemen, welcome to the party.
It's my opinion. I can still be patient. I'm just trying to wonder if I have a response or not.
Yep, you're
Spicy start. We're going to back up.
We are here in the case of Monique Cooley versus Jasmine Jackson, case number 23-09874PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And today is the time and place set for an evidentiary hearing on whether or not the respondent, Ms. Jackson, violated a protective order protecting petitioner Ms. Cooley. So at this time, I'm going to invite Ms. McNabb to place your appearance on the record.
Thank you, Your Honor. Lord McNabb on behalf of petitioner.
Very good. And Ms. Jackson, you're here without an attorney, so would you state and spell your full name for the record, please? And you're muted, Ms. Jackson.
Hello?
Now I can hear you. Go
Can
ahead
you hear
and
me?
your full name
I'm
for the
sorry.
record, please.
First name Jasmine, last name Jackson, Jasmine. Jackson, Jackson.
Very well. Thank you, Ms. Jackson. And the way the hearing will go today is Ms. McNabb is here from the prosecutor's office. She'll present
I'm
petitioner's
sorry,
case.
it's a little hard hearing.
Okay, I'll get a little closer to mine. Maybe I'll maybe make it a little louder.
I can hear now, yeah.
Ms. McNabb will present petitioner's case. She's here from the Kent County Prosecutor's Office. She'll do that by calling witnesses. You will have a chance to ask any witnesses Ms. McNabb calls questions in a cross-examination type format, which usually are short, kind of yes or no type questions. And then you'll have the chance after Ms. McNabb presents witnesses to present any witnesses or testimony that you'd like to present. On your own behalf, you will be cross-examined by Ms. McNabb if you testify or if you put a witness on to testify. All that being said, Ms. McNabb, why don't you lead us off?
Thank you, Your Honor. I'd like to call Ms. Cooley.
Very well, Ms. Cooley, would you raise your right hand?
Oh, and Ms. Cooley, you are muted.
Oh, yeah, you'll have to unmute. Thank you. Oh, you're still muted. There we go. You solemnly swear or affirm that your testimony today will be the truth and nothing but the truth.
I do.
Very good. You may proceed, Ms. McNabb.
Thank you, Your Honor. Ma'am, could you please state your name for the record?
My name is Monique Cooley.
Just listen to this.
And Ms. Jackson, you're going to have to mute if you're going to talk at the same time or if you want to talk in the background. Otherwise, we'll hear you and it'll interfere with my recording of the hearing. So either you'll have to mute if you want to have conversations off the record or not have the conversations. So continue, Ms. McNabb.
Okay, thank you. Ms. Cooley, how do you know Ms. Jackson?
I know Miss Jackson. She's been having an affair with my ex-husband, soon to be ex-husband. So she's been having an affair with him.
Okay. Do you have any relationship with her outside of that?
No, never.
Okay. Do you recall when you obtained a PPO, or did you obtain a PPO against her?
I did.
And do you recall when?
I retained it October, like the 4th of October.
Okay. If I told you the judge signed it on October 5th, does that sound right?
That does.
And to the best of your knowledge, was that PPO served on Miss Jackson?
My friend tried to serve the PPO to her, and when she tried to serve it to her, I guess she tried to throw the PPO back to her and said sent me a text message out the same day stating that she received the PPO, and if I want to play foul, that she would I will be receiving my PPO in the mail. That's what she told me. So she was gonna go get one on me. She texted me and told me that.
Based on your knowledge, Miss Jackson had the PPO and was aware of it.
Yes.
I thought you was talking to me. I apologize.
All right. Where are my notes? Okay. And what led you to apply for this PPO against Miss Jackson?
She had been calling me numerous of times. She's been texting my phone. She rides past my house numerous of times. She's threatened me and my family. She told me that she had a gun and would do something to me and my family. So I felt that my life was in danger. And I felt that I needed the reason to go get me a personal protection order. She even told me that she wished that I had life insurance on me and my family.
Okay. And so when you were first getting these calls, how did you know that they were from Miss Jackson?
Like I said, my husband, I had a GPS tracker on him, and I didn't know who address it was at first. This girl I'm gonna go back. She assaulted me in Woodland Mall, and a situation happened. She fought me in Woodland Mall, and she tried to press charges when she was the aggressor. So they never even pursued charges on this case. So I didn't never know who she was. I never knew who this young girl was because she's a young girl, and so I had a GPS tracker on my husband, and it led me to that address. And I wanted to know who it was at the time. So I left my phone number inside of her door when I went over there. And she, from that time on, anytime, whatever situation they had going on, because I never even knew her, she's calling my phone nonstop, threatening him, threatening me. It's just got so out of hand that I had to be aware of my surroundings. When I go places, I run into this girl. She's popping off at the mouth, ready to attack me, do different things. So I fear for my life. I fear for my life.
Okay. I want to talk to you about what happened on December 31st. Do you remember that day?
Yes, I remember that day clearly.
Okay. Can you tell me what happened that day?
I was at home and I received a text message I got 3 missed calls. I'm like, hello? She like, Nikki, this Jazz. I'm like, what do you want calling my phone? Quit calling me. There's no reason to call me. She like, yeah, she got to talking so much stuff. I called the police with her on the phone. She was like, I don't give a fuck about no PPO. Bitch, I'll kill you and your husband. She was on the phone saying this stuff while I merged the police in on the phone call. So then after that, I started receiving text messages. This young lady even sent me a picture of her having sex with my husband.
And what did those text messages say?
I'll read the text message to you right now. I see why you mad now. Go suck his dick, bitch. That bum ass nigga who steal for a living just was at the store stealing yesterday. That's who you love. Y'all both lame as hell. He a booster, stealing everything for them kids. Was just stealing that dicks yesterday. All them outfits you seen is a real dummy. What I know you don't get niggas at all. That's why you got a son for a husband. I am done another year being a nigga doormat for you. Happy New Year. That's my nigga. I just gave him back. I was tired of him being at my house. I have it right here.
And then on what date did you receive that text?
I received that text December 31st.
Okay. Does Miss Jackson have any legitimate reason to contact you?
There's no reason you should contact me. I'm not your friend. I'm not nothing. I don't care what he got going on.
Just okay. And
Excuse me, ma'am. I'm sorry. Will I have a chance to voice my opinion? I can still be patient. I'm just trying to wonder if I have a response or not.
Yep, you're going to have a response and a chance to ask any questions that you might have for Miss Cooley.
Okay, thank you.
and Miss Cooley, have you ever contacted Miss Jackson?
Like I said, I left my phone number inside her mailbox, and I mean in her door. And when she talked to me on the phone, certain situations, because I didn't know that he was even having an affair with this girl. So when she called my phone before, but yeah, I had a conversation with her before prior. But when it got real serious to knowing that he was at home, then that's when all the text messages and just so like delusional stuff started coming to me. Like this is like she needs to be in Pine Rest if you ask me.
Okay. And then have you contacted her directly or indirectly since this
No,
PPO has been in
I
place?
don't contact. No, I have no contact with that girl.
Okay, thank you, Your Honor. I have no further questions.
Very good. And Ms. Jackson, do you have any questions for Ms. Cooley?
I don't necessarily want to communicate with her. I would like to just voice my opinion when possible, or voice my
No, I'll
statement.
give you a chance to make a statement on the record when it's your turn to present your side of the case, but I got to get through Ms. McNabb's case first. Ms. McNabb, do you have any additional witnesses or evidence at this time?
I do not, Your Honor. Thank you.
All right, now we'll move to you, Ms. Jackson. I'm going to first swear you in, Ms. Jackson. If you'd raise your right hand, do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Absolutely nothing but the truth.
Very good. And Ms. Jackson, go ahead and make your statement at this time if you'd like.
Okay, Your Honor. First, I would just like to say it is very intimidating, very scary that this woman would manipulate the courts the way that she is, especially when I have so much evidence proving my case. I have never threatened this woman as far as, with a gun or her family or anything, you know what I mean? There's nothing that her family has done to me that would make me feel that I would have to get revenge or anything on her. Honestly, this situation is just a manipulation. I did send you a letter with a lot of evidence. Excuse me. I'm not sure if you received it yet. I'm ready to show the evidence. Originally, I placed a PPO order on her. Adrian Cooley. This was back in May 15th, 2023. Monique came to my home on Sunday, May 14th, 2023. I have evidence, pictures to verify she was there. She caused a huge disturbance. Me and Mr. Cooley were asleep at my home. She came to my home distressed in boxers, in men boxers, in house shoes, and a t-shirt with no bra. I have evidence again to prove my story. She came to my home. She banged on my door.
What date are you saying that occurred on, Ms. Jackson?
This occurred on May 14, 2023. There was a police report that was made as well for the disturbance. She came to my home. She was very aggressive. My neighbor next door had to step in to pretty much, stop everything from escalating. The police were called because she entered my home, and the police reported that she entered my home, but she exited before, the police arrived. Your Honor, I have this woman really trying to terrorize my life because Mr. Cooley, she cannot control the actions of Mr. Cooley. He's a grown man. I understand there had been an affair going on, but at the end of the day, you know what I mean? I'm not the only one who's overstepped boundaries, and I've always been single. I've never been married. So this has not been my issue. The only reason why this woman is continuing to try to pursue charges against me is because she is very upset about the situation. I have just had another police report that was filed on Sunday. I can give you the number. It's too early for me to give you the report, but I can give you the case number. This woman came to my home while she has a PPO on me, and she pretty much called the police to my home because she thought Mr. Cooley was here. There were 3 police officers that came to my home. Came outside to talk to them. They explained the situation. I have a live recording of the police officer telling me she told Miss Cooley, it does not look good for you to be on her premises when you have a PPO on her. Also, Your Honor, I just placed another police report for last Friday. Monique Cooley, her daughter, she has 2 daughters. I don't know their last name, Janaya and Nevaeh. I have all type of verification. I've been, this is an open investigation. She drove these 2 young ladies over to my home to steal my surveillance camera on Friday because she felt like I would not be able to prove my evidence. I have a witness who, they saw her, they heard her voice. She did not get out of the car. But my neighbor, because she is familiar with Miss Cooley after everything that's occurred at my residence, she's told me that Miss Cooley drove these 2 young ladies over. They actually stole my surveillance camera. I have a open investigation going on. So what this woman is trying to do here is she is trying to assassinate my character because she does not like me based upon the situation, which I understand. I have never threatened her. I have never come to her home. She cannot provide any surveillance footage of me being at her home. I'm going to show you footage of her being at my home on multiple occasions. And it's to the point I'm afraid for my life. My son cannot play outside because this woman comes to my home on a regular basis. And for her to pretty much come to my home while she has a PPO on me is just to the point where I feel like I can't do anything. You know, I feel defeated here, Your Honor. It is just not fair to me, the circumstances. I'm a college student. I'm also pursuing a small business. I have a child that I'm trying to take care of. I do not disturb this woman. I am not a violent person. I do not do any of these things. So if I can show you my proof that this woman has been harassing me and that she is the harasser, I can get to that right
Well,
now.
we're not gonna, because that would go more towards either taking away the PPO or second, that would support a PPO.
We
But
have footage of her at my house right here, sir. This is one picture of her at my home.
Also, Your Honor, I would object to any surveillance footage as I have not been provided it and have not had a chance to review it.
This is another
Yeah,
footage of her.
you know, Ms. Jackson, at this time, because the issue is the question of whether or not you violated the one that's in favor of her. I'll hear your testimony that she is provoking this by showing up or trying to intimidate you on the other side, but I don't need to see the surveillance.
I understand.
Just testify and I'll weigh it.
I understand, Your Honors. I was never served a PPO. The woman that she claimed served me a PPO wrote on the court papers that she served me a PPO by Coach Lane. But my surveillance camera shows this woman at my house when I was not there. So I just feel like if she actually did come to my house, why would you lie? Because Miss Cooley drove her to my home. I caught them when I was leaving, when I was on my way home. I seen her parked on my premises. So she went out of her way to try to drive this woman to my home to serve me a PPO when that's a violation itself. You know, this woman is clearly playing games, and it's just very unfortunate.
Okay, all right. I think I have an understanding of where you're coming from. Ms. McNabb, do you have any questions for Ms. Jackson?
Yes, Ms. Jackson, did you send Ms. Cooley any text messages on December 31st?
Your Honor, I'm sorry. No, I did not. I'm not sure what type of game she's playing, how she got these text messages or so. I have a phone number that I can't verify the text message that was sent, but anytime I text her, ma'am, it was just at the time when me and Mr. Cooley were going through our differences. And since she was harassing me so much, I was reaching out, telling her like, hey, can you please get your husband? He's back over here. I don't want you to be coming to my home. So I was contacting her, but I guess she was already in the process of being done with him. So everything that I was doing was agitating her. I've never caught her phone harassing her. I don't own a gun. I've never, I don't know why she would lie in court like this. This is really insane to me.
Okay, so the text message that Ms. Cooley read out loud, you're saying that you didn't send that.
That is absolutely false, ma'am. I've never talked like that before. Me and her have had arguments, but I have never texted her those words, and I don't know how she can prove that that's me, but I can assure you, right hand to God, that I have not texted her those things.
And have you texted her or called her at all since the PPO was in place?
I was not aware when the PPO was in place because, again, it was never served. But when I did speak to her at whenever time, she did inform me, like, you're not supposed to be calling me. I have a PPO. And I'm like, okay, I'll leave her alone. I just wanted to let you know that he has been back over here and I don't want you to come disturbing me. So I'm letting you know, just as communicating, I've not harassed her. So this is very disappointing to be going through this situation.
Okay, I have no further questions, Your Honor.
Okay, and I do not have any follow-up questions either. So thank you. Unless Ms. Jackson, there's additional testimony you'd like to give at this time.
I do not.
Okay, then you may step down from the witness stand. Any additional witnesses or evidence you'd like to present, Ms. Jackson? And I did not receive your letter yet or the attached evidence, so I haven't reviewed that in connection with today's hearing. It sounds like most of that goes towards, it might support a protective order on your behalf,
It was
Again,
denied. I actually
Cooley,
tried, and for some reason they denied it, and I'm gonna try again.
well, and sometimes with a protective order, I can tell you it's as straightforward as Michigan law does not allow what we call reciprocal protective orders, and that I can't say, well, one on you and one on her. That you know, you have to have a separate basis for it. But if you send in the evidence, then I'll consider that like I consider all of the
Well,
submissions that I made.
farewell. Will do. Will do, because I have to be safe as well, sir.
All right. Then I think we're to the time for a closing statement. A closing statement, Ms. McNabb.
Actually, Your Honor, would I be permitted to call Miss Cooley as a rebuttal witness? Just briefly?
You may. Ms.
Okay.
Cooley, you do remain under oath. You may take the stand again.
Yes.
Okay. Miss Cooley, you've heard Miss Jackson's testimony, correct?
Yes.
Okay, and she alleges that you were at her home on Sunday. Were
I
you near
never-
her?
I was never near her home.
There's
Sunday.
a police report with it in it. I just
Man,
want you to
I'm
know.
talking, ma'am.
Hey,
I'm
let
talking,
her
ma'am.
go.
There's a police report, so before you lie, just be honest.
I'm talking, ma'am.
Okay.
Yep. You'll get a
So-
chance to ask her questions again.
Did you
Ms.
recently go anywhere near her home?
So I told you Monday, I went over to her home, went over to Wingate Apartments. Never did I go to her home. I called the authorities on my ex-husband. And that's when I called the police and went towards that way with the police.
It was my premises.
Against my husband. And she has nothing to do with nothing.
It was my premises. My premises. He was here. It
Nobody
my
was never
premises.
near your premises.
Okay.
Okay, hang
Right.
on, Ms. Jackson. I'll give you a chance to ask questions.
I'm sorry, sir. She's just lying, and it's not fair. We're on court. How are you lying?
This
I have a
girl is
police report.
delusional.
Verify
She
it.
has
Hang on, we can only have one
She
person
is
talk at a
crazy.
time.
Okay, sir. You're right, Your
I'll-
Honor.
Yep, I'll have you hold off, Ms. Jackson, but I'll give you a chance to ask questions after Ms. McNabb's finished with her questions.
Okay.
Go ahead, Ms. McNabb.
And Miss Cooley, why did you call the police?
I called the police because my ex-husband took some expensive belongings from my home. I was taking my niece to Wingate Apartments to apply for an application. And when I got towards that way, I synced his car there. So I called the police while I was at Wingate Apartments, and the police came towards that direction.
They knocked on my
Because
door.
I'm not talking to you.
They knocked
Okay.
on my door, Your Honor.
So you were not there to have any, you were not there with anything having to do with Miss Jackson?
No, I never went to her premises, ma'am. This girl
Okay.
is making up a whole delusional story.
The police report will verify this. Is pretty scary. You want to lie like this.
Girl,
Hang
shut
on.
Hey.
I'm going to give you a chance, Ms. Jackson.
It's just crazy, you know. It's crazy, Your
Ms.
Honor.
Jackson,
You know.
I'm going to need to mute you, though, if you keep kind of cutting into the testimony, because all this gets recorded and it becomes part of the record in case either side wants to appeal my decision at the end. So I only can have one person talk at a time.
Fair enough. I apologize.
You
And,
may continue, Ms. McNabb.
and Miss Cooley, how do you know that Miss Jackson's the one who sent you those text messages?
She called me from the number 50 times.
Okay.
She
And
called
which-
me from the number, and not only that, she texted me the stuff. I had her on the phone with the police. I merged her in with the police talking on the phone.
Okay. And you recognized her voice?
I know her voice, yes.
Okay,
She's
how many-
called me a million times. She's delusional.
Okay. Thank you, Your Honor. I have no further questions.
Okay, and Ms. Jackson, do you have any questions that you would like to ask Ms. Cooley at this time?
Your Honor, I just want to say Miss Cooley did not actually come to my door, but she was in my parking lot. I have a parking lot, and the police did not allow me to pretty much even leave my home. She was on my premises.
She's lying.
And I have a video of the officer who she, spoke with, and the officer just pretty much confirmed. She said, I did inform Miss Cooley that it doesn't look good for her to be at your house on your premises when she has a PPO on you. Those were her exact words, and I can verify that. I can verify that.
Okay, any other questions, Ms. Jackson?
Nope.
All right, any further, Ms. McNabb?
No, Your Honor. Thank you.
All right, then, thank you, Ms. Cooley. You may step down from the witness stand. Any rebuttal or additional witnesses at this time, Ms. Jackson? Ms. Jackson, any additional witnesses?
I don't have any present as now. I didn't know if I would need them right now, but I do have relatives. I have family who is very familiar with this situation. So, if that's a future thing, I will have them. But as of now, no.
Okay, all right. Well, then I think we're to the time for the closing statement. Ms. McNabb.
Thank you, Your Honor. Ms. Cooley has testified that she received several calls from Ms. Jackson on December 31st. She has testified that she recognized her voice on the other end because she had heard her voice over the phone many times. And she has testified that she received that threatening text message from the same number that called her.
She was just at my house March
oh.
8th. She was just at my house March 8th with clothes. I have
Yep.
her on camera with her face
That's not
covered.
me. That doesn't show my
Hang
face,
on,
like it shows yours.
Ms.
We're
McNabb
not talking to you.
is speaking now. Let's let Ms. McNabb make her closing statement, and then you're going to be able to make one, Ms. Jackson, and then we'll be finished.
And Ms. Cooley has also testified this has been ongoing and continuous harassment. I believe the court should find her testimony as credible, and find that Ms. Jackson has at the very least violated the PPO once, if not more than once. Mrs. Cooley has explained why she was in the vicinity of Ms. Jackson's home on Monday. That had nothing to do with Ms. Jackson, that she was doing something for her niece, and there was a dispute between her and her husband. So the court should not take that into consideration. Thank you, Your Honor.
Thank you. All right, Ms. Jackson. You're muted, Ms. Jackson. You'll have to unmute, or I'll have to unmute you. There we go.
Okay, Your Honor, I just last would like to say, it is not a thing on her ex-husband or soon-to-be ex-husband. If the police come to my home and actually knock on my door, there were 3 police officers she sent to my home because she's seen his vehicle at my house. If you ask me, that is a form of harassment. If you're driving past and you have a PPO on me and I have been violated by contacting you and you just notice your husband's car and you send him to my home and you're parked on the corner of my house speaking with the police about the situation, it's harassment, it's manipulation. And I just feel like, how can I possibly live my life in peace with this woman antagonizing me on a regular basis, Your Honor? I have no problem minding my business. I'm not confrontational. I don't have enemies. This woman has done so much to me. But like I said, I am in school. I don't have time to just sit here and document every little thing until it came down to this right here. I have the police report verifying that she was not at Wingate, that she was on my premises. If I'll be able to provide that, you'll be able to see that I'm not making the situation up. This was just a manipulation, because she was upset about him being at my home.
Okay. All right. Well, I have heard the testimony today. There haven't been any documents that were introduced into evidence on this matter. And the question is can I determine beyond a reasonable doubt that text messages sent on December 31st of last year, that is 2023, were from respondent Ms. Jackson, and second, that those messages violate the personal protective order at this time. And Ms. Jackson has denied that those were from her. However, the testimony from Ms. Cooley has been, well, I recognized her voice on the phone, and thus I knew it was her calling me. In addition, there were an allegation that there were some text messages here following the calls, including one that Miss Cooley has testified to, was in sexual nature involving her soon-to-be ex-husband, Mr. Cooley. I will note that Mr. Cooley is at the midst of this dispute, and of course is not here today testifying in either things. It strikes me that sometimes in these cases, a man is the root of the trouble, and the man somehow misses out on these proceedings, even though he may be as much at fault regarding both parties as certainly anyone else involved in the case. But that being as it is, I still do have a protective order in place that protects Miss Jackson Miss Cooley. And I will find at this time that there has been evidence beyond a reasonable doubt that those text and or calls on that date, December 31st, prove that Miss Jackson did violate the protective order. Now, I'm not going to impose any jail time or fines as part of the sentencing. What I'm going to do, Miss Jackson, is I'll send you a letter indicating that you need to go down to the Kent County Sheriff's Department and get fingerprinted because I have found that you violated the order. And I will tell you if you violate it again, and that would be by either being, any of the violations. You can't be at her property, you can't text her, you can't call her, you can't go from an unknown number. But I mean, if you're sending a picture that's sexual in nature that you would be the only one that might have the possession of, logically, she's going to determine and probably be able to convince me that that was from you and be able to bring you into court here again. And next time, I certainly, having had you fingerprinted this time, might consider putting you in jail, though I'm not going to do that this time. On the flip side, I will caution that no matter how irritated Miss Cooley is with her ex and, maybe stealing stuff, and sounds like he certainly is adept at, kind of playing the two women involved in this matter off against each other, that nonetheless, the protective order, when it's in place, is intended to be a shield. That is, it protects you, but it's not a sword. It doesn't give you a blank check to do whatever you want with regard to Miss Jackson. And so, I would agree with, what was alleged to be a police officer's statement today that, that you shouldn't probably be over on her property. If you need to call the police and you think that's where your ex might be and might be located, well, you certainly, usually, I don't find that police contact and calling the police is usually a good basis for a protective order. And that's because when the police officers do arrive, it's not direct contact between the other person and the respondent or whatever. It is, the police officers exercise their own discretion when they get to a scene and investigate. So, it may be that the police get called because there are legal proceedings. There's a divorce case apparently and others ongoing between Miss Cooley and her soon-to-be ex-husband. And, he seems to be kind of drifting maybe between two different locations, maybe more, where he is staying, and certainly seems to be playing a role in this. And acknowledging that, there's no way that a protective order orders the two of you to be friends or to have a good communicating relationship with each other. I don't expect that to happen. However, I do expect both of you to kind of, I say it's like the referee in a boxing ring where he, says to the two boxers, each of you go into your own corner, neutral corner, and stay there. Don't recommence the fight until, don't recommence the fight. How about that? But definitely not while the protective order's in place, because while it's in place, at least with regard to you, Miss Jackson, you are correct in your assessment that it isn't fair. You're you're the respondent. You've got everything to lose. Whereas you'd have to convince me, on the flip side, that Miss Cooley was more to blame than you were. If an incident did happen, your safest course of action to protect your studies and your life that you're building entirely separate, it appears to be, from Miss Cooley, is to just stay out of sight and out of contact with her. And even if you get angry at Mr. Cooley, I don't know if he's still involved, but do not use Miss Cooley as a way to reach him. You got to figure out a way to get to him directly if that's still an issue between the two of you. I don't have to decide that today, but don't use her as the go-between because of the existence of this protective order. So I'll send you a letter. It'll give you a couple Saturday mornings when you can go down to that sheriff's department. I say to people when they do that, take a look. You're only going down there for a visit. You're not going to jail. There's nothing criminal about it. This is a civil case. You're just giving your fingerprints. However, if I do find you in violation and order you to go to jail after a hearing, that's where you'll wind up, and it'll be for several nights, as punishment for violating the court's order. I'm not doing that at this time. Most people take the warning the first time and say, you know what, I don't want to spend any more time than I have to. here at the Kent County Jail or with the Kent County Sheriff's Department, and don't have any problems. But the order does remain in place, and I will caution both parties to continue to observe the order. And as I said, it is a shield and not a sword. So that is the conclusion of today's hearing. I will thank both parties for appearing by video today, arguing your case, and also participating in this. I haven't seen, as I said, your evidence, but I will review it if it comes in, Ms. Jackson. And if you've applied for a protective order, I do consider each one of those as they come in individually. If you can support one, you may be able to qualify as well. But in any case, what the court process indicates to me is that you're both willing to go through this legal process, even though it's slow and not always very satisfying, as a way to defend your protect your rights and protect yourself, rather than taking it in person or via each other's families to each other, things like that. That's exactly what protective orders are designed to do, is to get people into court and not coming to blows with each other in the street. So you're both respecting that process, and I'm grateful for that. I will send out the follow-up orders, and with that, we're concluded.
Thank you, Your Honor.
Thank you.
All right, can we go? All right, can we go to Ms.
I don't know what I'm doing. I have no clue what I'm doing. Oh, wow. Thank you. Thank you for that. Thank you for that. That's awesome. Okay. That was our warm-up. That was the warm-up. That's all that was, because I know like a bunch of people have seen that already. The next one is out of the Detroit Detention Center. It's a magistrate hearing, and it's spicy. That's all I can say. I've seen most of it. The young lady in the Wayne County Detention Center is not a happy camper, and the magistrate kind of loses his cool too. So let's check it out together, huh? What do you think? Yeah, let's just do it. Thank you everybody for showing up. This is, oh God, thank you for that. Thank that thing. Thank you for that. I don't even know what to say. That's really cool. And this is the 25,000 subscriber special. Thank you everybody for showing up. We've had an amazing turnout so far. We've got quite a bit more to go. We've got a couple. Let's see. Let me just look at my thing here. I've got 3 more videos here. A total of about a little bit more over an hour to go. So stick with me. We're going to start with the Wayne County Detention Center. We're going to move on to Middleton, who had a little bit of an eviction situation that was, I thought, pretty interesting. And then we have our chili video that we all want to watch together and see what this guy has to say about chili. So stick around. We still have a lot of a great show to go. So come in, have a chat, and thank you everybody for showing up. This is just really cool. Really, really cool. So back to the videos, huh? Back to the videos. Nope. That one. I don't know how to click the right buttons. Wayne County Detention Center.
All right, can we go to Ms. Ashley at the Wayne County Jail? Ready on that, Mr. Rod? She got 3 cases.
Ready, Judge.
All right. Before we proceed on the cases, I've got 3 capious bonds. Has there been any update on those bonds? Mr. Murad?
On Miss Ashley, Judge, I have no authority, but they're misdemeanors. I just make the argument that this court can change it.
All right. Before we go forward, before we proceed on the main matter, I've got Miss Ashley has some tickets in which you've got to address. Ticket P. First of all, ma'am, you got some traffic matters which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside those arrest warrants for your personal bond in each of these misdemeanor matters It carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. Can't afford attorney. One will be appointed on your behalf. Is that clear?
Yes, I got a question though.
Hold
The
on.
point that
Hold
you're
on.
talking about.
Hold on. Let me finish. And I suggest you don't say anything while I'm talking. And if you have any questions, address them to your attorney, which you will be able to do in a few moments, okay? All right, the tickets are P1148755. Leaving the scene of an accident, personal injury, driver license suspended February 22nd, 2021. Ticket P1530187. Supplying false information to a police officer, loitering, solicitations, receiving and admitting, December 15th, 2023. Ticket 194573481, July 8th, 2019, no insurance misdemeanor. You were given a no cash bond, personal bond, each of these matters. Pretrial, April 19th, in courtroom 533 for your tickets. Now, I'm going to call in successive order your 3 misdemeanor files. Case number, state your name for the record, ma'am.
Chanel Ashley.
All right, calling case number 20045868801. Peace Michigan versus Chanel Ashley. Malicious destruction of personal property less than $200. Case number 22045460001. Pearson, Michigan versus Chanel Ashley, assault or assault and battery. And case number 210447561. Pearson, Michigan versus Chanel Ashley, child abuse 4th degree. Appearances, please.
Lisa Coyle appearing on behalf of the people, Your Honor.
And Ryan Marad, PA 3665, on behalf of Ms. Chanel Ashley. We waive the reading. Ms. Ashley stands mute. She's been advised of her rights.
All right, court order not guilty plea on behalf of Ms. Ashley for all 3 cases. Argument as to bond on all 3 cases. They're misdemeanors.
I understand that.
Now, it is a $1,000 10% bond set by Judge Bryant, March 15, 2024. The malicious destruction of property case, bond was set July 5th, 2023, $100, 10%. Any reason as to why I should not continue this bond?
She was in the county on her last capias, but she has capias a few times.
Can I make my record? She has 5 cases, Your Honor. She has 3 misdemeanors in this court, and she has 2 felonies pending in Third Circuit Court before the Honorable John Gillis. And on all 5 cases, she has capiases. She also was sent to inpatient. She failed to appear and absconded for that. So I'll start with the misdemeanor on the MDP. Her capias history begins back in January of 21, which she was granted a personal bond. Then I can tell you it went to in March of 21 to 500, 10%. Then she was in June of 21, she was granted another personal bond on the arraignment. Then by August of 21, she was given 500, 10% by Judge Bryant for her failure to appear. Then in August, she was granted another personal bond. Then by November of 21, she was failed to appear, so she had a 510% granted. Then she went and was arraigned on the capias. She was given another $10,000 personal bond in February of 22. She fails to appear. So in April of 22, she was given a 110% bond by Judge Bryant. Then when she was arraigned on that bond for failure to appear, she was given 110% with a tether by Magistrate Kilpatrick. Then in April of 23, she went to bond redetermination, and before Judge Williams, who was standing in for McConico, he gave her a $1,000 personal bond. So 2 months later, within 2 months, by June 1st of 23, she fails to appear. In July of 23, she had a bond set again by Judge Bryant, $100, 10%. In September of 23, then she was granted a personal bond by Magistrate Ecartea. In November of 23, she failed to appear. In January of 24, she failed to appear. In January 24th of 24, she was given $1,000, 10% by Magistrate Acartea. She then was gone to redetermination. It was lowered to $100 personal bond, and a tether was added. And then here we are with another failure to appear, and it's 1,010%. This basically, I could go through all of these cases, Your Honor. They mirror the same KPS history, as well as her two pending felony cases, which in fact, that started in July of 23. She has two cases, a UDAA and a resisting and obstructing before Judge Gillis. In both cases, she failed to appear several times. July of 23, she failed to appear for arraignment on the information. On October 16th of 23, she failed to appear for pretrial. In January of 24, she failed to appear. A bond then was given at $10,000 personal with the tether. She then again turns around within a month and fails to appear. She was ordered to inpatient drug treatment, and she absconded from that. She has criminal histories in Indiana, Illinois, and Ohio per the APA notes. Your Honor, the other two misdemeanors go hand in hand with the same. I could make a record if the court wants, but I don't see the point. She does not come to court. And this court, unfortunately, keeps granting her personal bond, and she still does not come to court.
Mrs. Cole, you made a sufficient record as to the continuation of the cash bond. Response, Mr. Rod?
Judge, briefly, Ms. Coyle's correct with regard to a lot of the previous KPSs. I know that with regard to the last KPS, she indicated that she wasn't brought from the Wayne County Jail. Looks like she was granted a personal bond and a tether on March 12th. And I see a KPS on March 15th. I'm not sure if she was ever released, but obviously I'll take Ms. Coyle at her word if she was ordered to inpatient and just never showed up. I'm not sure if she was actually released in time with the tether, but nonetheless, I'd ask for either for personal bond or if the court would consider personal bond with tether.
Well, given the well-established record set by Mrs. Coyle with respect to KPS in 3 cases, and not only that, in the felony case, I'm going to continue the bond set by the judge. In the misdemeanor matter, $100, 10%. Child abuse case, $1,000, 10%. And assault and battery, $1,000, 10%. There's been a well-established history of KPS here. Bond redetermination matters on Monday, March 25th, not in front of Chief Judge McConico. Pre-trials on all of these will be May 15th, 9 a.m. in front of Judge Bryant. Condition of bond, no contact with Destiny Ashley, no contact with Victor Long, you're not to possess any handguns, firearms, or other dangerous weapons, and no contact with Josette Houston, and no contact with the Auburn Street address. Is that clear, ma'am? Is that clear, ma'am? Miss Ashley, is that clear?
Can I ask a question now?
Yes, ma'am.
Cause just like I was in jail for them court dates and I missed it on the 15th, I was also in Haven with where I told them I had
Miss Ashley,
no,
your attorney,
but you denied you bond and
hold
stuff
on,
and making me stay in jail. You said I can't ask a question.
You're not stating a question. You're stating facts. What is your question?
My question is, I don't understand why I have to stay in jail and get 10% because in all these cases, look, but you said I'm asking a question. How you keep cutting me off if you say I can ask a question? You said I had a statement at first. I rephrased it and I'm putting it in question form. Why are you steady cutting me off?
Can I answer your question?
I ain't even get a chance to finish the question before you can ask the question, answer the question.
Go ahead, ma'am. Finish your question.
My question is, the reason why I missed all them court dates, because if you ask her the dates on them, they correspond with the dates that I was in the mental health program. I just let them know in the mental health program that I did have court dates. They assured me that I would go to the court dates and be present during there. But it wasn't a court date that I was supposed to have. It was about a shot. And I said it several times. Each time I'd have been in the court in the mental institute around my court dates.
Okay, Miss Ashley? Miss Ashley? Miss Ashley? Miss Ashley?
See, this is what the fuck I'm talking about. What?
Okay, that's it. Have a good day.
I'm
so am I.
And that's how you end your that's how you ask a question and never get an answer and never finish your court hearing it all at the same time. It isn't that amazing? But I just want to ask a question. All I want to do is ask a question while I'm making a statement. If I can't ask my question while I'm making the statement, then what are we even doing with ourselves? All right, enough of that. Enough. This next one is a Middleton. So yeah, we're about halfway through our show here, and got Middleton and Chili up finally after this, and it's not actually Chili; it's a Chili fan. So I don't know. Maybe that's Chili con carne. I'm not sure. I'm not sure how that goes. Anyway, we'll get to that when we get there. This next one is interesting for a variety of reasons. It's involving an eviction process on a pretty interesting property, and again, just gonna let you watch it and let you make your own decisions on a. Yeah, it's vegan chili because it's not the actual chili, right? I'm sorry. I'm getting distracted. I'm looking at chat. I shouldn't do that. It's easily to get distracted like that. Hey guys, I just want to while we're on this break, throw this out there. This is our 25,000 subscriber celebration. I want to thank everybody who's shown up so far. We're having a lot of fun right now. And we're going to watch a couple more videos while we're having this little celebration. While we're doing this, I just want to throw this out there and make the announcement again that now that I've hit 25,000 subscribers, I am planning on doing a little thing that I'm going to call Lunch with Lone Wolf. It's going to be a Saturday morning show, morning lunch-ish show. It's going to be brunch, basically. It's just exactly this. You're watching exactly what it's going to be like. And we're just going to do it around noonish Eastern Standard Time every Saturday. It's going to be cutting room floor material, stuff that I necessarily haven't been able to find time to watch, haven't been able to find time to make a video out of. So we're just going to watch it together. You guys are going to comment on it live, and we're going to laugh, and we're going to have fun, and we're just going to, commune, do that type of stuff while the animals go crazy in the background around me. So, I hope you enjoy this next video. It is a Middleton. All these videos are from yesterday, for the most part. I think they're all from yesterday, so they are fairly new. This one has a couple of interesting factors, and I'll just let you determine what the interesting factors. What is most interesting about this case to you? Because I feel when it comes to this case in particular, a lot of people are going to find a lot of different aspects of the case differently interesting. We'll just see how it goes, right? I mean, that's what we do around. Let's watch the case together, shall we?
Good morning, Mr. Roberts. Can you hear me?
Yes, I can.
All right, very good. Can you close that door?
Yeah, give me a second. How's that?
Very good. Good morning, sir.
Good
I would
morning.
have you come right here in the courtroom, but if we need to have a breakout room with legal aid, we can do it from where you are. So why don't you have a seat? Good morning. You're here on a landlord-tenant case. Your landlord isn't here yet, but Ms. Foster is asking you to move out of this property at 309 South Main Street.
Yep.
As such, you have the following legal rights. You have the right to
obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. And there will be a legal aid attorney here with us if we need some advice. You have the right to have the case heard here in St. Joseph County where the property is. You have a right to a trial by a jury or by the court. If you demand a jury trial, you have to do it here today at this hearing. Or you have to file a written demand within 5 days and pay the $50 jury demand fee unless you get a waiver of that fee from the court. In this case, your landlord isn't asking you to pay rent. She's simply asking you to move. Your lease expired in January. If you are able to reach an agreement outside the court with your landlord and file a conditional order of dismissal, the court must tell you where to find the form or provide that form with you. If both parties are agreeable to mediation, I can set the matter for mediation and help facilitate that. I appreciate your being here in person on time. And like I said, you're in the breakout room, not because I'm afraid to have you here in the courtroom, but if we need to have a consultation, I can do it from there. Are you still at 309 South Main?
Yeah, I don't have any other place to go right now.
All right, well, let's wait for Miss Foster to join us. She is late. That happens a lot, Mr. Roberts. I had two previous people this morning that one lady is almost a squatter. The other lady owes about $5,000 in rent. And neither one of them really had anywhere to go or made any provision to find a place to go. But this landlord-tenant process is a process where the landlord goes through a number of legal steps to try to remove you from the property and get the property back. Now, she doesn't list any reason, but when the lease is expired, I guess she doesn't have to have a reason. I had several cases where the landlords wanted to get out of the landlord-tenant business. They wanted to sell the house. And the tenants were in there and the buyer wanted to buy the house and move in. So the tenants hadn't done anything wrong. The landlord just wanted their house back. And so we'll see. I'm not sure where Miss Foster is. How long have you been there?
I don't remember the exact date, sometime June, July 2023.
I could look at the lease.
Yeah.
July 7th of 2023.
Okay.
Have you looked for a place to go?
I have, but with my felony, it's hard to find a place. And when I'm being on Social Security and unable to find a job, I can't afford an apartment. And I'm on a couple waiting lists at the government assisted, what are those called, subsidized apartments. And well, like I said, I'm on the waiting list. I haven't heard nothing.
Yeah, every one of them has a waiting list. How about your parents' old house? Could you go back there with your sister?
I'm waiting on the polygraph test. My PO, every time I ask her, says she's waiting on the guy that does it to schedule her. So that's all I know. That would be what I would like to do, is move back in there, but that's not an option right now.
Okay. Does your PO know that you've got this notice to quit?
Yep, I'm supposed to get a hold of her after this meeting to let her know how it went.
Who is your PO?
Bobby Joe Newland.
Did she help place you here in this place?
Yes, and she did give me another number that I called, but that guy said he's got 2 other people interested, and he's supposed to be getting a hold of me with a yes or a no when they give him a yes or a no, and I haven't heard anything back yet.
All right, well, you haven't been sitting around. It sounds like you've been proactive. You're on waiting lists, you're talking to other landlords. This place is kind of a transitional housing for felony defendants that Miss Foster runs. It's almost like a rooming house. But I don't know where she is.
I don't really know how to say this. I believe it's legal aid that just texted me, but they reminded me that I'm supposed to mention the reason I believe she's evicting me is back in November, I lost power to my room completely. No lights, no outlets, no nothing. So I put my rent in escrow, and I am missing a month's worth of rent in escrow. I had to buy gas and things like that at 1 month. But I still have no power in my room at all. And I stopped paying rent so they would fix it. And they did a couple of things that worked for a few hours, and then they quit working. And then they just stopped working on it and gave me an eviction notice.
Meg, so Meg, you're aware of this case?
I am. I obviously couldn't disclose that until he did. But yes, I am aware of this case.
Well, that's certainly a legitimate reason to withhold your rent, that you don't have any electricity in your room. Do you have plumbing? There's a common bathroom kitchen, is that correct?
Correct. Yep. I have a bathroom and a kitchen and an extension cord that runs under my door. That way I can run my sleep apnea machine at night. But even that outlet doesn't work quite right. If I try to plug more than 2 things in, like a phone charger and a TV, it shuts off and kills the breaker.
All right, well, I'm gonna give her about 5 more minutes and then I'm gonna dismiss this case for plaintiffs failing to appear. Sounds like you need to get out of there anyway, Mr. Roberts, so it does sound like you're looking for other options. How much, well, how much is the rent? Let me look at this lease. So you're contending it's a retaliatory eviction for withholding the rent.
Yep.
Now, this is in the city of Three Rivers, and Three Rivers has a code enforcement officer. And as a rule, most of the, not most, the properties in Three Rivers generally are up to code, which is reassuring for me. When the properties are out in the townships, it's like the Wild West. Some of the stuff you couldn't rent it in Three Rivers or Sturgis because it isn't up to code. This doesn't sound like it's up to code. How long have you been without power?
I got it wrote down. Give me 1 second. Memory says November 28th, but I'll give you an exact date in a second.
And Judge, I can tell you that we've made a Freedom of Information Act request to the city. We did that on Monday and are waiting for the response still.
Regarding the inspections?
Exactly, yeah.
I just got a new phone and I don't have my old notes, but November 28th, if it's not the exact date power went out, it's very close.
Well, that's a good date. So, all right, I'm just gonna leave you here for a minute. And I don't know where Miss Foster is, but if she doesn't show up, the matter's gonna be dismissed. So stay right where you are. And Meg, if you'd stay with me, I have a general civil case at 10. And the defendant, Miss Lehman, is here, Miss Hagan, but I haven't seen either of the plaintiffs. Miss Hagan, can you hear me?
I can hear you. Do you want me to start my video or no?
Did I accidentally include a
Well, you
different,
can wait.
different case?
The cases are both set for a continued. Wait a minute.
And I think that's one of the big issues with what's happening in his case.
Here's Preston Nate. Yeah, Miss Hagan, why don't you turn your stuff on?
Okay.
Are you off school today?
We started spring break today.
Oh, okay.
Well, I guess I included a different case. I'm not sure. I honestly, I should have skimmed through this one a little bit better, it looks like. Yeah, but normally, you know, I at least, I mean, you know how I do it.
Mr. Nate,
James.
can you hear me?
I look for the gaps and then I kind of like try and remove the gaps and that type of stuff.
Yes, Your Honor, I can hear you.
Okay.
Good morning.
Shut up.
Morning.
We have two cases this morning involving LVNV funding versus Jacqueline Lehman, now Hagan.
Yep.
For the first time in about 10 weeks, the air handling system just turned on. It
Do,
sounded like a freight train.
Do y'all actually want to
The file
watch this
number in the
intermediate
LVNV
case, or do you want me to
is
just jump over it?
231204. There's another case, JP Morgan Chase versus Jacqueline Lehman, now Hagan, 231057. We've kicked the can down the road on both of these cases for some time. There are motions for summary disposition set in each case, and they're set for this morning. I had some trouble scheduling this, so we actually moved it ahead. Mr. Nate had an issue and Ms. Hagan had an issue, so we settled on this morning. You've been working for some time and trying to get some resolution here. We started way back in October. Mr. Nate, what's the status here?
Well, it's my understanding, and maybe Ms. Hagan knows a little bit more, but she was or is still working with Clear One Advantage, as my understanding, to kind of get these debts resolved and kind of help her figure out some payment plans that would work for these. From our end of things, we just haven't heard from them. So they haven't reached out to contact us really on either of these files. So nothing's been worked out. So that's why we filed these motions to kind of keep the case moving and maybe wrap it up on the court's end. But that's kind of the status of where we're at, I think. And like I said, Ms. Hagan might know a little bit more about that. But from our understanding, she was working with Clear One Advantage. They just haven't reached out to us yet.
Ms. Hagan, what can you tell us?
Well, I called again yesterday just so I could have like an update, you know, a more recent update for this morning. So there were 9 accounts originally. They settled on 7. 2 have dropped off now. So they said there's a few more accounts that will be paid in full here soon. And then that frees up more money to work with to negotiate the last 2 accounts, from what I understand. They can negotiate sooner if I were to deposit like a large lump sum. Like I have an account where I pay them $700 a month. I think it's $693 exactly. And so that money is what they have to work with to make the payments for the other, you know, for the everything that was in the debt consolidation program. So they were trying to work on like what a total would be, like what I would have to deposit more for them to like settle the last 2 accounts. There just wasn't any more money left with the monthly payment that I was currently making, is basically where we're at.
Well, we've been delaying things. Neither of those are a defense to the fact that you owe this money. And so we've not entered a judgment. But at this point, my inclination is to grant plaintiff's motion for summary disposition, have these judgments enter, and then you can work with your company to try to make them as part of your debt consolidation program. But I did explain this before, but let me take a minute again. We had a session this week, Mr. Nate, with all the judges. One of the sessions was on dealing with unrepresented defendants in collection cases. And very, very few of them understand the concept of summary disposition. So they filed a lawsuit against you and claimed money damages. Let me go back. This motion for summary disposition doesn't have the dollar amount in it. They filed a lawsuit against you and they served it on you, and you filed an answer. And that started this process where we had a pretrial. In your answer, you didn't deny the debt and you didn't present any legitimate or significant defense to the fact that you owed the money. This is a lot of money. In the JP Morgan case, it's $17,133.05. And in the LVNV funding, that one's smaller, it's $3,942.55. So they filed the lawsuit, you filed the answer, we set it for a pretrial. The summary disposition motion says there is no material issue of fact and the defendant has not stated any defense. It just is what it is. And we ask that you simply enter a judgment on our behalf. They filed it under MCR 2.116C10. Mr. Nate, I don't have a judgment in the JP Morgan.
Yeah, I apologize, Your Honor. For some reason,
And
I don't think it was.
the motion doesn't have the dollar amount in it. But it's $17,135.95 plus costs.
Well, to clarify, with the JP Morgan account, it would just be the amount paid for in the complaint, the $17,133.95. Chase requests us not to pursue any costs on their files, so it would just be that $17,000 amount.
All right, would grant summary disposition in that case. And ask you to submit an order under the 7-day rule.
Absolutely, thank you.
Now, in the LVNV funding case, let me see if I have an order in there.
And I apologize, you probably don't. If there wasn't one, I apologize I didn't get in there.
And LVNV funding is under 2.116C9 and C10. And again, the motion doesn't have the dollar amount in it. In that case, the amount is $3,942.55.
Yeah, and this one would include the court costs.
All right, so we have a filing fee of $95, service fee of $59.58. Do they do the statutory attorney fee?
We do not. It would just be the filing fee and the service fee.
All right, so that's $154.58. equals 4,097.13. Again, I'd ask for an order under the 7-day rule.
I can get that prepared. That's not a problem.
Now, let me explain that also, Ms. Hagan. I made a finding in each case that you had not stated a defense and there was no material issue of fact. And I granted their motion for summary disposition as to each file, which is about $21,000 worth of debt. These are no longer a lawsuit, they are a judgment. And you can present this to your Clear One Advantage representatives and try to make them part of your repayment agreement. But there's no need for a trial here because the standard for summary disposition has been met by the plaintiff. We've adjourned this since October to try to get some resolution and we didn't get there. Under the 7-day rule means he's going to submit the order, 2 separate orders, one for each case. And if they say what we put on the record here, you don't need to do anything. They'll just enter. But let's say he puts the decimal point in the wrong place and it says you owe $170,000 instead of $17,000. Hopefully we would catch a mistake like that. But if you have any objection to the order, you have 7 days to let us know that you object. Otherwise, the orders will enter. But as soon as you get them, I would suggest that you share them with Clear One Advantage.
Okay. So I have to
And
pay this.
maybe the reason why they haven't reached out to these companies is because there is no judgment. Now there is a judgment in each file that says you owe this money. You're doing your best to try to not declare bankruptcy. You've had issues. Your husband's had serious medical issues. You're doing the best you can to paddle as hard as you can to keep your head above water. And I do respect that, but you incurred all these debts and you're trying to resolve them one by one. So you're going to get 2 copies of 2 separate orders in the mail within the next few days, and you have 7 days to object. Do you have any questions?
Do I just pay that in one lump sum?
No. No one has $20,000 just sitting around in a pile. They could pursue collection, like garnishment of your wages or your income tax. If you don't have any money, you don't have any money. They aren't going to come, pry the gold fillings out of your mouth, but they have a judgment that says this money is owed. Now, you've been working with this company on at least 7 other debts.
Right.
My advice is you include these with those other debts and try to work out a payment plan. That's what this company is allegedly doing for you. And Mr. Nate, both of these clients are familiar with this company and dealing with it. So it isn't as terrible as it sounds. I mean, you already owed the money. Now I just made a finding that you owed the money. But no, I don't expect you to just write him a check for $20,000. If you have it, great, but I don't expect that you do. At any rate, that's my advice. You share these with your credit management company and they can work with Mr. Mr. Nate's office and see if they can come to some sort of payment agreement. Okay?
Okay.
Do you have any other questions?
No.
All right. I'm glad we were able to do this on a day you didn't have to miss school.
Yeah, no, I
Mr.
appreciate
Thank
it.
you also. All right. We're good to go on both files. Thank you.
Thank you, Your Honor.
All right. Mr. Roberts, I'm going to file an order dismissing your case.
What does that mean exactly, as far as where I can live goes?
Well, you can live there. The case is dismissed. Plaintiff failed to appear. If she wants to evict you, she's either gonna have to make a motion to set this default aside or start all over again. If you don't have any electricity, I would advise you continue to follow the advice of legal aid and put your rent into escrow. Which is good also, because you may need it for first month's rent and deposit at another place. But ultimately, you need to get out of here. But maybe she talked to somebody and I don't know. But if the city comes and inspects it, they might condemn it. Then you got a whole new problem. That you can't live there because it's condemned. But you keep doing what you're doing to find other housing.
Yes, Your
You
Honor.
still have your driver's license?
Yep.
All right. Well, you got irons in the fire, both at your old family home, at some other places, but I don't like this, that you're living there with no electricity. But you've got legal advice and this case is dismissed. So she can't evict you. If she wants to, she has to start all over again. Okay?
Yep.
I will send you a copy of that order. In fact, let me see if I got one in here. Elaine, would you do an order, a landlord tenant order, so I can show that it's dismissed and give it to Mr. Roberts before he leaves? All right, Mr. Roberts, go out to the office. I'll get you a copy of this order before you go.
Okay, do you want me to hit leave on a little button down here?
Yeah, that's good.
All right. Thank you, Your Honor.
Thanks. Well, I don't like that much. I got Department of Correction, probationers, parolees living in this house, and it is not up to code. I suspect your FOIA is gonna stir things up with the city inspection department.
I did wonder about that. I've reached out to a couple other connections that I've got to get a little more insight on what's going on with this property. It's listed on the Department of Corrections list of potential homes to move into. So we'll certainly stay in touch on.
Well, we certainly have a need for that. He also has some other problems. He can't live close to a school, and he's got some other issues that make his housing more difficult, but hopefully they can work something out.
When you asked the defendant to back up, did he follow?
Uh-oh. Uh-oh, uh-oh. You see what this is? You see what this is, right? Oh my God. Oh my God. We're not quite there yet. But yeah, our last defendant, Mr. Roberts, had, wow, lots of other issues. Oh my God. So this is it. This is the last video. We have reached the finale of our show. And it's going to be an interesting one. This is not a court case, people. We're not watching a court case together. We're watching another YouTuber's video. I don't know who it is. I'm not going to advertise it. I just want to show this because it's so wow. It's this guy. I'm just, so I don't have to like start it and stop it immediately. I just want to set this up. Within the first 5 minutes of this video, you're going to hear this guy insist that Chili was not arrested for doing anything illegal. You're going to hear him insist that Chili broke no laws. You're going to hear him insist that the judge is completely biased because of the way she treats Chili. You're going to hear him insist that the judge is running her court. The judge's court in which the judge has all of the authority in an inappropriate manner. You're going to hear him insist that the judge speaks to Chili in inappropriate ways. Yeah, this is the stuff that I saw just in like the first 5 minutes that was like, I gotta watch this with somebody that's not just me, that will want to scream at the screen as loudly as I do. Now again, I got my first taste of this from a guy who purported to be a lawyer who's out there on YouTube someplace. And the video for the lawyer stuff, if you just want to go to YouTube and search Free Chili DeCastro, you'll find the videos. There's like 3 of them. They're all like an hour and a half long. I don't have that much time in my life to, I mean, I'd love to. Maybe if y'all want to like schedule that and like us all watch those hour and a half long, 3 hour and a half long videos while this guy reviews a 30-minute video. I don't know about all that, but this lawyer agrees with this guy about all this stuff. But okay, we'll throw this out there. The lawyer guy is self-admitted friend of Chili DeCastro who agrees with a lot of apparently Chili DeCastro's points of view. So I'm not sure how much of a lawyer he really is. I mean, there's lots of different types of lawyers, right? And just like when it comes to doctors, you got good doctors and you got stupid doctors. I mean, just because you have a doctorate doesn't necessarily make you a brilliant person. Just same thing when it comes to lawyers. Just because you're a lawyer doesn't mean you're brilliant in all aspects of law. He may be really brilliant when it comes to contract law, but not so much when it comes to criminal law. I don't know. But this video is unique. Let's just get into it. I've set it up enough. Right before we do though, thank you everybody. This is the last video of the 25,000 subscriber celebration. I want to thank everybody for showing up and celebrating with me today. And I want you to tune back in with me every Saturday at 11 o'clock Central Standard Time, noon Eastern Standard Time, for Lunch with Lone Wolf or Brunch with Lone Wolf or whatever the heck we're going to call it, because we're going to go live every Saturday for a little while to watch some court cases and fun videos together. That's what we're going to do now that we've hit 25,000 subscribers. It's just how it's going to be. So, on with the show. If I can figure out how to work things.
When you asked the defendant to back up, did he follow your order?
No, he did not.
Okay.
I gave him 3 additional warnings.
Okay, I've got to stop it immediately right here because this guy, where he's showing this in the video, where the cop is actually asking him to back up, and the actual time marks on the video, they don't comport. He's using this video inappropriately, and sure, it's the cops' body cam footage, but where Chili is standing right here is where he was standing when the police officer was saying back up, back up, back up. Not right here. So I don't care. This guy sets up a lot of non-factual things such as this through the course of this video. Let's see if it enrages you as quickly as it did me. I'm just going to shut up now.
To back up.
Okay, and did he obey those orders?
No, he did not.
I don't really want to be part of your YouTube channel.
So you already are.
Great.
You already are. He's a pig.
Excuse me?
I said he's a pig.
Okay. So I'm not going to permit you to speak to anybody in my courtroom in that manner. He wants this. He wants to get arrested. He wants to get into an altercation with police officers. He welcomes this. This helps his YouTube channel. He called the officers here in my courtroom today pigs. He called and he's nodding his head up and down. So apparently he hates every law enforcement officer in the United States. All right. Please stand up, sir.
Mind your own business. I'm a member of the press. Go get in your car and do your job, little doggy. Go feed her. You're being detained right now. Okay, then detain me.
An American is locked away in a concrete and steel cage for the next 180 days.
because he deserves it. I've got to pause it right there. An American is locked away in jail for the next 180 days, 6 months for those who can't math very well, because that's me. 6 months because he freaking deserves it. He broke laws, and in association with the legal regulations comporting with those laws, a judge has sentenced him appropriately for the laws which he broke.
He damaged no property, he stole no property, and neither harmed nor threatened to harm any other man or woman on this earth. He's in jail on 2 charges: obstructing a public officer and resisting a public officer, in a
which are both illegal.
Single incident that took place on March 15th, 2023 in this parking lot at this exact location in the parking lot at 4155 South Grand Canyon Drive in Las Vegas, Nevada. Thankfully, the incident was recorded on at least 2 cameras. And if you remain objective, you're going to see exactly what happened that day. And if you're honest, you'll conclude that a man is sitting in jail for absolutely no reason.
Okay, no. He is absolutely sitting in jail for a reason. And I just want to start here. You don't need to be objective about this. Your feelings and objectivity have no bearing in the legal ruling of a person breaking the law. That's the point of laws. Laws are definitively actually objective. What you're describing here is if a person is subjective about their definition of what law is. But laws are objectively recorded registries entered into legal documentation by legislators and litigators, and they are things that you can find on the books. Just because you may agree with them or not, or know about them or not, doesn't make you not subject to them as a citizen, and that's just part of the, social contract. Now, I think this is interesting.
The American sitting in the cage is Chili DeCastro from the YouTube channel Delete Laws. And it really doesn't matter what you think of him. It doesn't matter if you like and support him. It doesn't matter if you hate and deride him. The question is he guilty of breaking a law? If so, what law did he break? Did he commit a crime? Did he create a victim? Does he really deserve to be in jail for a single hour, let alone 180 days? Did he get a fair trial? Was he well represented? Was the judge impartial? Did the cop who was involved give a lawful command? What does lawful even mean? And just as importantly, and people who support Chili may not like this consideration, did Chili conduct himself in a way that would not psychologically disturb the people who already stagger under the drunkenness of their own unbridled power?
So right there, you can already see the bias by which this creator is coming from in this situation. And he asked the most asinine question: what do you call lawful? Again, he's taking a subjective stance of what is lawful, which is idiocy. What is lawful is objectively cross-referenceable. You can know what is lawful simply by looking up the statutes in the law. It's literally in the name of the thing you're talking about. And I know I'm taking a very layman stance on this. Keep in mind, I am not a legal professional. I'm just a dumb guy with an opinion on this situation. And this stuff is silliness.
Now, this is an hour-and-a-half court proceeding, and I'm only going to comment on what I consider the highlights. The link to the entire video will be provided in the description. Here's the awkward initial clash between Chili and Judge Ann Zimmerman.
Are you Mr. DeCastro? Can you turn off your phone, please? The one that's in your hand.
Just communicating with my lawyer. He's on his way here now. So I'm just waiting for him to get there.
All right, I'm gonna wait for your attorney, okay?
Okay.
Thank you.
Thank you.
All right, Jose DeCastro, 23 CR 013015.
Good morning, Your Honor. Agnes Botello, Lincoln Cave for the record. Good morning, State.
Good morning, Michael. Me on behalf of the defendant, present with me this morning.
So I have signed 2 media requests that permit recording or photographing these proceedings, but I have not granted any other requests to record or live stream these proceedings. So I need Mr. DeCastro and everybody else who wants to stay in the courtroom to surrender their phones, or you can leave.
Are your phone covered and I'll take one or you can exit.
Americans have to know that nearly every courtroom across the land is a Constitution-free zone. You have to disarm and you have to follow the court rules, which hardly ever line up with the Bill of Rights.
They don't need to line up with the Bill of Rights. That's why it's called a Constitution-free zone.
Zimmerman demonstrates her disdain for Chili's rights and the rights of everybody else in the courtroom to personally record and act as press. She makes it clear that it's her courtroom, she's in control, and only allows certain people to record.
That's called being an administrator over a proceeding, which is literally her job, dude. So, I mean, I don't know why you're taking umbrage with the fact that the judge is literally doing her job to the best of her ability. Move on.
Now here's the friction between Chili, the judge, and the court bailiff.
I need Mr. DeCastro to empty all of his pockets.
What's that?
Empty your pockets
and give up your phone to the judge.
Okay. This next action we're going to see here is contemptuous.
I have to give you my phones?
Yeah.
My phones have to be completely off.
Yeah.
He's questioning the judge
I don't really want to
and
be part of
refusing to
the
follow her
meeting.
order.
So,
You already are.
great.
You already are.
Awesome.
I'm not gonna get into this guy though. I'll get into someone else. I'm
No,
not touching myself.
no, they're gonna go to my marshal.
Now, why is he approaching this completely different person who he has not been approved to approach? Why didn't he just give his phone to the individual in which he was ordered to give his phone to? I mean, what an asshole move.
He's a pig.
Excuse
And he's a pig.
me?
I said he's a pig.
Okay.
That right there, ladies and gentlemen, sealed the deal for him. That didn't necessarily get him the max sentence immediately, but I think he already had the max sentence when he came in here because she knew what was going on. She already knew the situation. She's studied up on this guy. He was already looking at 90 days, but he was probably looking at 90 days at the same time. So he was probably just looking at 90 days hard time, or whatever you want to call this. This is Las Vegas jail he's going to. But that right there, that action right there, I think that action probably earned him his consecutive time.
Sir, I'm not going to permit you to speak to anybody in my courtroom in that manner. And if you don't want to apologize, I'm going to hold you in contempt.
I apologize to the court, Your Honor.
No, you can apologize to, they've done nothing to you.
Actually, Your Honor, when you were here, you came over and gave me a directive for no reason and started telling me what to do.
Okay, well.
I have all the respect and love for the court. I follow the rule of law all the time.
No, it is their job to maintain the safety and security of the courtroom.
I agree with you, Your Honor.
So you want to speak like that in my courtroom, I'm going to hold you in contempt. And if I hold you in contempt, you're going to jail. That is not my wish. Okay?
I wish either.
All right. So I need you to empty your pockets too. Suit pocket, pants pocket.
This is illegal. This is a violation of my Fourth Amendment.
No, it isn't.
Yes, it is. I don't have any recording devices on me. What are you talking about?
How about your suit jacket?
I don't have anything on me. This is preposterous.
No, it's
This really
not.
is.
No, it's not.
Yes, it is.
Mr. Me, your phone too. Off.
They're recording everything.
They have a media request.
Right, and I'm not recording anything.
But you are being contemptuous with the judge. This is just so stupid.
Your guy here took my phone, so his phone's not on.
Right.
Ladies and gentlemen, never talk back with a
Take
judge
the
like
phone
this.
too?
Ever.
No, I'm not gonna
Don't
take
ever
the word
don't ever
for it.
talk back
He's
with a
an
judge.
officer of the court.
Calling a cop a pig in a courtroom is not advisable when you're standing before a black-robed agent of the state who's already exhibiting signs of extreme bias against Chili and his YouTube channel. The court marshal clearly didn't have to grab the phones out of Chili's hand in that manner. From the start, the deck is already stacked against delete laws. As we've seen many times before in countless videos, when the fragile egos of authoritarians are damaged, any semblance of rationality and fairness evaporates. They are now no longer psychologically able to stay on the task of judging by objective law. They are now governed by their frail emotions.
And see, this is where you're wrong, dude. This is exactly where you're wrong. She is able to use objective law. She's not using her emotions because she is following the codified ordinance of the law.
Chili's in this situation to begin with. He damaged the unstable emotions of Officer Brandon Bork during his traffic stop.
And see, here he's setting up, he's poisoning the well by suggesting that this is all because he hurt someone's emotional feelings on a traffic stop and the police officer just was so hurt by the situation. No, dude. Chili created a clear and present danger for a police officer who was in the middle of a traffic stop by inserting himself into a situation in which he was not a part of to start with. And I just want to throw this out there on the front end as we're watching the rest of this. I'm going to start getting a little bit more quiet, but this is my last salient point that I'd like to make. Anybody who does this type of stuff, anybody who just walks up to a stranger and inserts them into their life activity, like Chili did in this situation, is invading personal space. It's not right. It's crazy. It's not something any normal human should do on a normal, regular basis. It makes people feel uncomfortable. The poor lady in the car was already embarrassed because the cop was wedged in behind her and she couldn't go anywhere, and she was feeling embarrassed about whatever the situation was that she was going through with that police officer. Then this complete stranger comes meandering up to her car with a camera out. She's probably thinking in her head, what the hell is going on here? Who is this person? Am I in danger? Is he about to get into a fight with the cop? Am I going to be in the middle of gunfire? What is happening? The same thing's probably going through the cop's head. You know, what is in this guy's hand? What is he doing? Why is he inserting himself into this situation? Is he going to escalate this situation to where I'm in danger? Is he putting the life of this citizen in danger who I've just pulled over for a minor traffic infraction? All of a sudden it goes from a minor traffic stop to felonious interfering with the duties of a police officer. And to be clear here, I realize that he's not charged with felonies. In my mind, this is a felonious action. He's actually charged, I believe, with misdemeanors, but still, he's put the life of this police officer in danger by creating the distraction and making the situation a lot more tenuous than it should be. I don't know if people agree with me on that, but that's my big takeaway here, and I'm going to be a little bit more quiet, and we'll watch this together.
So let's review why Chili's here.
You good? Why'd they say that you were pulled over?
Before you were leaving.
Oh, I see.
Like, what a
Oh, I see. Oh, gotcha.
You can film, but you need to stay away from my driver. Back up. Back up, or I'm going to detain you.
You're gonna detain me how? In which way?
Get away from my car.
Actually, I'm standing right here. I'm at least 10 feet away, officer. I gotta tell you, I'm a constitutional law scholar. You can do whatever you want, but just understand something. Your name will go on the lawsuit. Mind your own fucking business. Mind your own business. I'm a member of the press. Go get in your car and do your job, little doggy. Go feed her.
You're being detained right now.
Okay, then detain me. Oh, she's free. Oh, you're gonna detain a journalist?
Yes.
2015, Rodriguez.
Come over my car.
Don't put your hands on me.
Come over.
Don't touch me. Don't put your fucking hands on me. No, you're not. I gotta make sure. Hey guys, make sure you guys get my people on the phone. Oh, this is so you ended the stop, you dunce cap. Did you just end the stop? So that's
Yes.
a 2015.
Come over here to my car.
No.
Come over here.
No.
Need an additional unit.
Bring your supervisor, please. Bring your supervisor, please. Don't touch
Come over
me.
to the car.
You don't get to put your hands on me. Don't grab me. Don't grab me. Listen, you're not. First get your supervisor out here. You're not just gonna grab me and throw me on the ground. You've already released You've already released her. This is 2015, Rodriguez versus United States. I'll walk right in front of your car. Let's go. Sure, come on. Come on.
You need to set the phone
There you
down.
go.
on
No,
the hood.
no. I'm a constitutional law scholar. You can't take away my
Set the phone down on the
I'm
hood.
now.
You're
I'm
being detained.
Please,
Now you're going to put hands on me.
No,
Come over here.
Why are you grabbing me?
Come over here.
Sure.
Now, Officer Bork takes the stand, preliminary questions are asked, and this is the relevant part of his testimony.
Initially, when I saw him, he was just recording. I ignored him, continued my records check. Then when he came over to the driver and started speaking with them, I got out of the car, approached the driver, and told DeCastro to back up.
When you first laid eyes on the defendant, approximately how far away was he from the driver of the vehicle in the Hyundai?
Approximately somewhere within 5 to 10 feet.
Okay. And you indicated that he was recording?
Yes.
Okay. What did you see that led you to believe he was recording?
He had his cell phone camera pointed directly at me.
Okay. And so is that when, upon seeing him being that close to the driver, is that when you told him, you walked up to the driver of the stopped vehicle and asked Mr. DeCastro to back up?
Yes, once he started talking with the driver.
Okay. And why is it that you did that, officer?
Well, I can't have unrelated people next to my traffic stops. I don't know if he's a dangerous person, armed. He could be a boyfriend of the stopped person. It's for my safety and the safety of the person I've stopped.
Okay. Because you're also in charge of the safety of the individual that this unrelated individual is making contact with. Is that fair to say?
Yes.
Okay. And so you saw it as an officer safety issue as well as a safety issue for the driver?
Yes.
Okay. And so when you approached, well, you said he was recording, the defendant was recording. At any time, did you tell him to stop recording?
No, in fact, I told him he can continue recording.
Okay. He can continue to record given what?
As long as he backed up and gave me an appropriate distance to work.
Okay. And so when you asked the defendant to back up, did he follow your order?
No, he did not.
We're going to come back to this because this is a lie that can be clearly demonstrated.
And so what did you do next?
I gave him 3 additional warnings to back up.
Okay. And did he obey those orders?
No, he did not.
This is another lie.
And what, if anything, did you do with the driver of the
Neither of
stop
those
vehicle?
answers were lies.
At that point, I chose to release the driver of the Hyundai and then focus my attention on Jose DeCastro.
And subsequently, did you turn your attention on the defendant?
Yes.
And can you tell Judge Zimmerman the nature of your interaction with the defendant after that?
I ordered DeCastro to the front of my patrol vehicle while pointing at it and told him that he was detained.
Okay. And what was the purpose of detaining him?
For obstructing my initial traffic stop with the Hyundai.
Okay. And did he obey your lawful order?
No, he did not.
When they get to this point where the prosecution brings her laptop up to the stand to show Bork's body cam footage, They have serious problems with the audio feedback, which is, in my opinion, unacceptable and ridiculous. For the sake of clarity and focus, they should have a system that anybody can easily plug into so that they can make a case without unnecessary technical difficulties.
Well, dude, it sounds to me like you need to get your butt over to Las Vegas, Nevada, and get yourself hired on with the court system so you can advise them correctly about how to set up their telecommunication systems for their court hearings. Because as it stands, your personal opinions about how their telecommunication systems are set up best for their court hearings makes no difference whatsoever at all. This stuff is set up so they can record this stuff for the court purposes, not so you can watch it on YouTube and hear it well. You dunce cap.
I'm going to overlay what the court played with Delete Law's recording of the incident, and then we'll break it down.
You good? Why'd they say that you were pulled over? Oh, I see. Oh, I see. Oh, gotcha. You're gonna detain me how? In which way? Actually, I'm standing right here. I'm at least 10 feet away, officer. I gotta tell you, I'm a constitutional law scholar. You can do whatever you want, but just understand something. Your name will go on the law sheet. Mind your own f***ing business. Mind your own business. I'm a member of the press. Go get in your car and do your job, little doggy. Go feed her. Detain me. Oh, you're gonna detain the journalist? 2015, Rodriguez. Don't put your hands on me. Don't touch me. Don't put your f***ing hands on me. No, you're not. You guys get my people on the phone. Oh, this is, so you ended the stop, you dunce cap. Did you just end the stop? So that's a 2015 case. No. Bring your supervisor, please. Bring your supervisor, please. Don't touch me. You don't get to put your hands on me. Don't grab me. Don't grab me. Listen, you're not. First get your supervisor out here. You're not just going to grab me and throw me on the ground. You've already released her. This is 2015, Rodriguez versus United States. I'll walk right in front of your car. Let's go. Sure, come on. No. I'm a constitutional law scholar. You can't take away my phone. I'm now
detained. You're going to put hands on me.
No. Why are you grabbing me? Sure. Let the phone roll. Why are you grabbing me? I'm a member of the press. I'm not doing anything.
So the cop's testimony is that Chili didn't step back.
When you asked the defendant to back up, did he follow your order?
No, he did not.
Okay.
Let's take a look at this clip. When the cop walks away from his cruiser toward the driver, Chili is clearly standing with his right foot inside the white line and his left foot on the white line. He backed up, beginning with his right foot, then his left. He's clearly 2 or 3 feet back from where he was initially standing before being told to back up. The left image is where Chili was standing before being told to back up, and the right image is where he was standing after he was told to back up. Now, the cop says he didn't back up at all.
When you asked the defendant to back up, did he follow your order?
No, he did not.
Okay.
The camera says he did. Cops lie, cameras don't. The judge should have thrown the case out on this alone. Assuming Chili's shoe size is close to a foot, it seems obvious that he's at least 3 feet back from where he was initially standing. In my estimation, he was 10 to 15 feet away from the driver's side door after being told to step back. During the cross-examination, attorney Michael Mee asked Bork this question.
How many feet did you order the defendant to back up specifically?
I never had an opportunity to give him an exact distance.
How far back did you intend to have him back up, even if you didn't express that?
In the background of the video, you could see that there was a parked semi-truck and a light pole. I would have directed him somewhere in that area, which would have been outside the 21 feet.
Your testimony is you never told him an exact distance to back up, correct?
Yes, he never allowed me to.
What do you mean you never allowed you to?
I asked him to back up, and he continued arguing with me, so I could never specify exact distance for him.
But you had time to give him 5 commands to back up, is that correct?
Yes.
Your testimony is he never backed up when you were giving him commands, is that correct?
If he backed up, it may have been inches, but he didn't substantially back up.
At this point, the attorney should have said, hey, this witness is lying, Your Honor. He's claiming that my client didn't allow him to state exactly how far he wanted him to back up, yet he could tell him to back up 4 or 5 times. He also claimed twice that my client didn't back up at all.
When you asked the defendant to back up, did he follow your order?
No, he did not. I gave him 3 additional warnings to back up.
Okay, and did he obey those orders?
No, he did not.
This witness has clearly discredited himself on the stand, Your Honor, and I have proof that my client did exactly what he was instructed to do, even though
he is not. You do not.
There's no law stating how far one must be away from a traffic stop, nor was my client told how far he must back up. So the defense attorney keeps pressing forward with this.
And you just reviewed the body-worn camera from your chest, is that correct?
Yes.
Okay. You didn't notice him backing up every time you directed him to back up?
He did not back up.
So you backed up 0 feet, in your opinion? Based on that video?
Not 0 feet.
So I just want to throw this out there. The standard gait of a step is not a single foot. So, you know, where the guy was making a big deal about, oh, well, considering his feet are such and such small, it doesn't matter. You know, when you just think about how you take a step when you take a step. Your step is about as wide as your shoulders, which could be anywhere from 2.5 to 3 feet. He may have literally taken 1 step back. We could give him 1 step, but 1 step is still only like 3 feet. It's nowhere close to 20 feet or anything like 20 feet. I'm getting started again, sorry.
What was that?
He didn't back up 0 feet. He was moving his feet. As to exactly how far he went back, I don't know.
Later, no.
But it wasn't substantial.
What would have been substantial in your opinion? Or what do you mean by that?
I would have guided him if he wasn't arguing with me back toward the light pole and the parked semi-truck.
And
would have been outside of the 21 feet. That was my goal.
So in your opinion, you have the ability, or you would in any traffic stop, ask somebody to move back 21 feet, is that correct?
Yes, for our training.
And what was that training?
That while we're conducting lawful activity, we're allowed a reasonable distance to conduct our activity.
But where do you get that 21 feet number from specifically?
That's taught to us in the academy. It's based on reaction time, normal human reaction time to a threat.
So your position is anytime you're engaged in any law enforcement activity, you would create a 21 feet perimeter?
Not necessarily. It depends on other environmental factors such as obstacles and barriers.
So your testimony is that every time you conduct a traffic stop, as long as there's no barriers, you would order a pedestrian to back up 21 feet, is that correct?
I would, yes.
The bottom line is, number 1, Chili was told to back up, and he did. Number 2, the cop lied and said that he didn't back up, then he said he did back up, and then he said again that he didn't back up. Number 3, there is no 21-foot law or any law specifying the distance one must stand away from a cop at a traffic stop. Therefore, no lawful order was given, and therefore, no obstruction occurred and no lawful arrest was made. What we have on camera is an attack by a man in a costume who was butthurt that he was told to mind his own business and was called a little doggy by a man holding a camera and exercising his press and speech rights.
No, that's incorrect. Your perspective is skewed, and you sound like a petulant child. You need to understand Chili was creating a clear and present danger. He was given clear orders which he did not adhere to. He created a distraction during the course of a police's official actions and duties. I mean, all of your assertions in this video that he did not break any laws or didn't do anything wrong is completely out of the atmosphere. It's stupid. This is the craziest thing I've ever heard, that somebody could have this point of view about this kind of situation. If this were you, if you were this police officer, heck, if you were the person in the car getting pulled over, you wouldn't want this situation happening to you. So shame on you for making this stupid kind of video that really tries to suggest that an injustice has been done because your feelings.
So now the cop leaves the stand, Chili enters the stand, and here are some of those highlights.
Yes, I do have I do have a YouTube channel, and the reason I have a YouTube channel is because of how many cops kill people every year, how many cops hurt, maim, torture, rape, and kill people every single year. It's such an epidemic that the rest of the world, I get thousands of emails saying, only in America does this happen. I started filming cops because when I was cheated in 2002.
Objection at this point, relevance,
Well, this is the reason I'm a member of the press.
this narrative.
So can you ask him a question?
Yes, Your Honor. What type of films do you make for your YouTube channel?
I only film police in their official capacity. I'm known across the country and across the world.
And why do you engage in that type of filming?
So I'm going to ask you, Mr. Mead, to direct your questions about the incident in question.
I was filming that cop because that's what I do for a living. I am a member of the press, and I invoked my right to be press. I always invoke my right to be press within the first 10 seconds of engaging with police, and I have thousands of videos that prove this.
Do you recall the officer telling you to back up?
Yes, I do.
And what did you do after he told you to back up?
I took a couple steps back. I just showed him that I was willing to back up a little bit. However, if I may, in Arizona, they created a 10-foot law.
Objection, relevance, we're not in Arizona, it's the state of Nevada.
So I'm going to allow it because I think that goes to why he kept saying 10 feet in the video, even though I will take judicial notice that you're not in the state of Arizona, you're in the state of Nevada.
Well, a federal judge struck it down, Your Honor, and...
Stop. Can you ask him a question?
Yes, Your Honor. Approximately how many feet did you back up?
I backed up a foot or two. I was at least 10 feet away from that car that the driver was pulled over in.
Did the officer ever give you a specific distance to back up to?
No, he didn't.
If he did, would you have complied with that?
Sure.
Did you believe you were complying with the officer's commands?
100%. I also informed him I'm a member of the press, I'm a constitutional law scholar, that this is what I do.
Do you recall him explaining why he decided to detain you before he arrested you?
He decided to obtain me because he said I was obstructing, which, from my understanding, is a physical act where I would have to get in the way. He said that the driver deserved privacy. I believe my First Amendment rights are not up for feelings. I think from the officer's testimony, we can see that he's scared of the driver, scared of me, scared of everything. They teach them to be afraid of everything. So I had 2 cameras out. It's identified as a member of the press. I'm sorry, repeat the question. I want to get it specific for the record.
Sure. The question was, did the officer explain to you that the basis of your detention was because of you not backing up or because of the privacy issue of the driver?
It was both. He said that, he told me to back up. I backed up a little bit. Then he said, she deserves privacy. And then I told him to go get in your car, little doggy, and write your ticket. And at that point, his face turned bead red, and his veins in his neck stuck out because we were over 20 feet away. And you had to holler to hear each other because the wind was probably 30 miles an hour.
After Chili leaves the stand, the prosecuting attorney says this.
Your Honor, the state asks you to find the defendant guilty of both the obstructing a public officer as well as resisting a public officer charged against him. The video very adequately portrays, and I don't think it's disputed by the defendant, what the context was of the interaction with the officer. I would venture to say that had the defendant just complied with the original order to not engage with the driver and
Real
to back up,
impressive.
we wouldn't be here. He
Real
wouldn't have found
impressive.
himself further engaging with Officer Moore.
See, the problem is the video shows that he did both of these things. He stopped engaging with the driver and he backed up. And the cop lied. So she rambles on.
No, it didn't. The video shows neither of those fucking things. Excuse me. I didn't mean to cuss like that. But that video doesn't show those things. Those two stills seem to suggest that he may have taken a single step backward at some point in time, but we don't even really know when in that conversation he may have meandered that minor distance between that line and that single stride gait to the point he was standing at in your second steal. I'm getting worked up again.
On for another 4 minutes, and then the defense makes his closing statement.
So first of all, you cannot obstruct an unlawful order. I disagree with the state that this is not a First Amendment issue. The First Amendment in this context actually has two parts. There's the filming and the right to film within a reasonable distance. The case law in all the federal circuits, Your Honor, there's no 21 feet rule that's been approved by any court of which I'm aware. That there is a 10-foot rule. That seems to be the rule that is applied by most of the federal circuits in interpreting the First Amendment. I submitted a bench brief that kind of goes through that issue, if the court's had a chance to review that.
I don't have that. When did you submit it?
It was submitted yesterday, Your Honor.
I mean, at this point, I would move to strike because it's untimely, but I got it this morning when I walked into court.
Go ahead.
So the officer's testimony that there's essentially this 21-foot distance where anybody can charge an officer and cause physical harm to an officer, if that is applied universally, Your Honor, it totally diminishes and violates the First Amendment. That is, as the officer testified, a 21-foot radius that he can attempt to impose. I believe his testimony was anytime there's not an obstacle between a person and somebody that law enforcement is interacting with. And that's just not what the law requires, Your Honor. The First Amendment gives their media, new media, old media, it gives individuals the right to film government agents. There's no dispute that that's the requirement, and if the officer is applying this 21-foot circumference to all law enforcement interactions, he's effectively eliminated the ability to film law enforcement going about their duties. The commands to not talk to the driver are also not based on any actual legal justification. There's no right to privacy in public, whether you're engaged with law enforcement or not. There's no requirement or no statute, no law that citizens can't interact with drivers that are interacting with law enforcement. So what's taken place here, Your Honor, is that this officer has taken it upon himself to essentially act as the legislature and created these rules that have no basis in any law and in fact are contrary to the First Amendment. Again, he can't obstruct an unlawful demand, so there is no obstruction of justice here. Resisting arrest, Your Honor, the court can see the video. Essentially what happened is he walked over to the front of the vehicle. There was some dispute about why he was being detained. That was discussed. The case law in that area, Your Honor, is that if it's an unlawful arrest, which it was in this case because they're essentially arresting him for violating these unlawful orders that they're pronouncing. Again, the case law is you can passively resist an unlawful arrest, and that's all that occurred here, Your Honor. Thank you.
I personally think that was a pitiful attempt at defending freedoms and proving innocence.
Well, your personal opinion doesn't matter because the judge is going to rule on facts of the case, not his rhetoric.
He simply could have constructed a bulletproof defense with bullet points. Fact. The cop lied. He said my client didn't back up when he
That's not a
clearly
fact.
did. The prosecution says we wouldn't be here if my client had obeyed the commands to back up and stop talking to the driver. Your Honor, my client clearly complied with both of these commands. So what's the problem? And I agree, we shouldn't be here. The video evidence proves my client is innocent, and if anyone should be on trial today, it should be the law enforcer who attacked my client because he got his feelings hurt for being called a little doggy and was told to mind his own business.
This is why you're not the lawyer defending him, because your stupid arguments make no sense and they have no legal basis or sound conclusions.
The fact is, Your Honor, this is supposed to be a court of law, not a court of feelings. My client broke no law. No lawful command was given. No victim was created. No crime was committed. There was no obstruction, and the arrest was a false one that should have been resisted. Your Honor, you simply can't have a lawful order when there's no law backing the order. Lawful order means any order, directive, policy, or instruction given by an authoritative source or given to ensure compliance with federal, state, or local law, which may be conveyed verbally or in writing.
We get a Google
There was
definition.
no law conveyed. But because the judge cares more about her feelings than any kind of law, and because she feels like officer safety trumps American rights, and because she endorses roadside extortion through traffic law,
I just want to point out that this guy literally showed the laws that that Chili broke and annotated them at the beginning of his little diatribe in this video. He has actually done that. Yet he still insists that it's not a lawful order. I guess his opinion trumps actual law.
This was her verdict.
All right, Mr. Castro, please stand. The problem with the argument that your attorney makes is it completely fails to consider the safety of the officer and the safety of the driver. The officer doesn't know who you are, and the driver doesn't know who you are. And you don't have any right to interfere with that officer doing his investigation and deciding if he wants to issue a ticket to this driver. And you also don't have any business approaching the driver. The driver didn't ask you for help. The driver didn't say, help, help, you know. You didn't see an altercation happening between the officer and this driver. The officer didn't protest that you were filming. There's no problem with filming. You can film, it's fine, all right? But you did interfere with his investigation. You did interfere with his ability to do his job. You did put him in a position where he is concerned for his safety and the safety of the driver. So I believe the state's met their burden beyond reasonable doubt. I'm going to find you guilty of obstructing a public officer and resisting a public officer.
In my opinion, there was no lawful basis for this conviction. There was only a subjective opinion that Chili obstructed and resisted.
And your opinion doesn't matter here because you're wrong. I mean, you can literally see in the video that what she said there is exactly what happened. And she is ruling based on Nevada law that is codified in legal registry.
This is a dangerous precedent that discourages transparency and penalizes those who would want to hold their public officials accountable.
You're
so then
lying.
The prosecuting attorney recommends that Chili attend an impulse control class, be charged $500 or the equivalent in community service, and serve 90 days suspended sentence on each count to run concurrent. After the defense claims that Chili believes in what he's doing and doesn't want to engage in wrongdoing, the judge reveals the real reason she's passing down such a harsh sentence.
When you say he doesn't wish to engage in any wrongdoing, it seems to me from observing him in the video that he wants this. He wants to get arrested. He wants to get into an altercation with police officers. He welcomes this. This helps his YouTube channel. He called the officers here in my courtroom today pigs. He called me, and he's nodding his head up and down.
I
So
agree with you.
apparently he hates every law enforcement officer in the United States. All right, please stand up, sir. I hereby sentence you to 90 days in the Clark County Detention Center on count 1, 90 days in the Clark County Detention Center on count 2, to run consecutive for a total of 180 days in custody. Thank you.
Sentence suspended or?
Oh, no, it can start right now.
And that right there, ladies and gentlemen, now I'm going to throw my opinion. Well, I've been throwing my opinion out a lot through the course of this video, but I'm going to throw my opinion about the original video. That was the best part right there. When Chili says suspended, she says, no, you can start serving it right now. That was the best thing I've seen in a long, long time of court watching. Oh my God, Chili. I'm sorry. I'm sorry that it means that you go to jail and you go bye-bye now. I'm sorry that that's what that exchange meant for you as an individual, as a human, because even though I don't like you, I don't think that a human should have to suffer in jail. But you legitimately did an illegal, very stupid thing that in other situations has gotten police officers killed. If the police officer ignores the situation and it ends up being a more dangerous situation than what you instigated, it could mean the end of their life or the life of the other individuals involved in a very mundane traffic stop. So you can't do this type of stuff, my man. You can't do this type of stuff. And the commenter here that created this video is just dead wrong about everything he's saying. And nobody should pay attention to what he's saying because it's going to get them in trouble, just like it got Chili in trouble, and just like it's going to get this commenter in trouble if he tries to live his life by this ideology.
Can you put you, please? I'm back to your share.
Bye, Chili.
This is a travesty of justice.
This is exactly what it is. A travesty of justice.
It's not
because
a
a man
travesty of
doesn't
justice.
like cops or their aggressive and deadly actions against Americans committed every single day.
Disagree. Hard disagree.
Please take some time to leave your thoughts about this in the comments below.
I'm
For those
taking
who
my
hate
time to make a
Chili,
frickin'
do you
video to
really
leave my
think
thoughts.
this was just? If you do, please explain. And for those of you who love Chili,
I can't believe people
what are
like
your
this.
views?
I can't believe my views are I can't believe people like you exist with these distorted views of social reality that we all live in. Those police officers are just trying to do their job, and some guy with way too much time on his hands approached them while they were doing their job and turned their job into a very threatening environment. So, I mean, just think of it like if somebody came to your McDonald's while you were cooking your fries and turned it into a threatening environment. Do you think that they should have that legal authority to do that while you're cooking your French fries? I don't think so either. And that's why we're just going to leave that case there. And that's going to end our show. That's it. That's it. There's no more to that. His video's over. He's going to make, please to, like and subscribe and all that type of stuff. And I'll be honest, I don't even remember where I got that from. I actually grabbed that and I didn't want to technically give it views as much as possible, but whatever. I don't know. Maybe I should be a little less. It'll be a little bit more forgiving and less vicious when it comes to that type of stuff. But I don't know. I just disagree with that guy and his point of view so dramatically. Anyway, this has been our 25,000 subscriber special. I hope you've enjoyed it. I've been your Lone Wolf Usul, your happy and faithful host for the Court Gallery. I am, in fact, the guy who types out all the nice, funny little comments. They're intended to be funny. Just throwing that out there. If they seem a little off color, sometimes I have some blue humor, so it's just kind of me. That's who I am. But welcome everybody. Join me on Saturdays. Now that we've hit 25,000 subscribers, I'm going to start doing a Saturday sit down, hang out. We're going to do similar stuff to this. I'm not always going to do like what we just did with that video. It's mostly going to be us watching court cases like we did earlier. You guys commenting, me making funny faces and commenting along with you, because that's what I enjoy doing. That's what I think is the coolest. So I'll have some cases from the cutting room floor that I haven't been able to watch, and stuff that I just haven't been able to have a chance to make videos out of, and we'll make videos out of them together, or just watch them together, or who knows, whatever, that type of stuff. So, that's what we're going to do. And I really appreciate everybody who has shown up and joined me for this little get together and this little special. We've had a constant flow of people coming in and out of here. It's been amazing. I've loved reading the chat and participating in the chat. So we'll do it again next week, 12 o'clock Eastern Standard Time, 11 o'clock Central Standard Time. Or what is it, Central Standard, or is it daylight? I don't even know anymore. It doesn't matter. Man, I hope we have a lot more fun. Keep it frosty in the comments. Let me know what you think. Even if it's bad, and I take critique too, it'll kill my soul and hurt my feelings, but that's fine. That's fine. I'm only human sometimes. Before midnight. Anyway, I digress. We're ending here, and we're gonna play our theme song. Hey, there it is. That's our theme song. Oh, we're gonna listen to this awesome song as we tune right on out. I'm going to watch Dune Part 2 later on this afternoon. I'm really looking forward to that. I'm excited to see where the channel goes moving from here. See y'all next weekend. Lunch with Lone Wolf. Watch some videos with me. See what happens. Peace out.
Like two different